After this particular lesson on staff rights and school law back in 2000, Patrick Barrett, a student in class, came up to me and told me that Steubenville City Schools refused to hire him unless he enrolled his child in their public schools, although he was told that he was the best candidate. He went on to tell me that his son had attended a Catholic school all his life and did not want to go to Big Red. He asked, "What should I do?" My advice, you need to talk to an attorney. The rest, as they say, is history. Here are the case facts. In May 1999, Barrett was scheduled to be interviewed for a full-time teaching position with Steubenville City Schools. Prior to the interview, Holub, a principal, advised Barrett that Rich Lucci would be the superintendent and would not give Barrett a teaching position unless his son attended Steubenville City Schools. When Barrett was interviewed by Steubenville City Schools administrators, including Lucci, he was told, "You have a future here because you do such a good job." In a follow-up interview, Lucci asked Barrett how his son felt about changing schools, and Barrett replied that his son was not happy about changing schools. Lucci informed him that it would be held against him if his son did not attend Steubenville High School. Lucci also explained to Barrett that the school board liked the teachers to enroll their children in the public school system because it looked good to those parents whose children attended Steubenville City Schools. Barrett began the 2000-2001 school year as a full-time substitute teacher, with the expectation that he would receive a full-time teaching contract. Barrett, however, reconsidered his decision regarding his son's education, removing him from Steubenville High School and enrolled him in Central Catholic. On September 29, 2000, Barrett met with Lucci and Assistant Superintendent. Barrett claims that Lucci told him he was being removed from his position as a fourth-grade substitute teacher at Wells. When Barrett questioned Lucci about the reason for his removal, Lucci told him that he was being disloyal. Lucci also expressed that he thought public high school would be better for Barrett's son. Barrett then reminded Lucci of his agreement to grant him a full-time contract after Barrett completed his 60 days of teaching in the classroom. Lucci became irate, denied ever making such a promise, and ordered Barrett to clean out his classroom that day. Consequently, in June 2001, Barrett filed suit in district court against the defendants, Steubenville City Schools Board, and Superintendent Lucci individually. Although not necessarily a freedom of religion case, the circuit court upheld the district court decision and stated, Barrett made a decision to send his son to a private school. Barrett's choice in directing his son's education is activity shielded by his constitutionally protected right of liberty, and the government cannot deny someone employment simply because that person is exercising his fundamentally protected right. In conclusion, public employees can be required to give up some of their constitutional rights, although certainly not all of them. The public employer can insist that employees waive certain rights, but cannot insist that employees waive others. It is clearly established that public employees cannot require their employees to vote a certain way, to go to a religious service, or to do a number of other things that are unrelated to public employment.